Good evening, and welcome to our very first Estate Administration Week at Edmonton Community Foundation. My name's Kathy Hawksworth, and I'm Counsel and Philanthropy Advisor at the Edmonton Community Foundation. It's my pleasure to host you this evening, and we're so happy you could join us. Many of you are also familiar with our Wills Week that happens every October. And this week, as you know, we've launched this new series of presentations specifically about the ins and outs of administering an estate. And the reason we do this is because at Edmonton Community Foundation, we have the opportunity to speak to many people who are either making gifts in their wills and estates or who are administering the estates and have become a trusted resource for legacy in our community. We help people provide permanent, ongoing support for whatever causes are important to them. So that's why we have many conversations with people about their wills. Now, before I introduce our presenters for today's session, I'd like to let you know at the end of the session, you'll be given an opportunity to fill in a survey. And as you may have heard, since this is our first time doing this, your feedback is going to be tremendously important to us. We do have a question and answer feature. You'll see the Q&A button at the bottom. But I will say that while all the other sessions this week have been very much around sort of the practical how to, who to appoint, that sort of thing, tonight is really about storytelling. And so we're going to give our presenters as much time as possible to share some more stories about how things can kind of go sideways when the plans are not in place. And so we may not have much opportunity to answer questions. One of the common questions is, will presentation slides be available? We're not using them tonight because it's storytelling. And you will find that this session is recorded and we will get it posted on our website by the end of April. It takes us a bit of time to do that. So with that, it gives me great pleasure to introduce tonight's presenters. Allison Barkwell works in all aspects of estate and trust planning and administration. She creates estate plans, prepares applications for probate or administration. She advises executors, personal representatives, trustees, and beneficiaries in both easy matters and what we call contentious matters, where the fight is on. She works with clients and carefully considers their personal situation and objectives, and gives advice on how best to organize their affairs. She enjoys working with both clients and their advisors, which include financial advisors, accountants, and other professional advisors. She understands how emotional estate disputes can be. In fact, she understands the stresses following the death of a loved one, so she can walk a personal representative and family through the tasks at their own pace. She's represented all sorts of folks, beneficiaries, adult interdependent partners, and personal representatives, and believes most claims can be settled prior to getting to court, and believes negotiation can be successful to save a lot of money in legal fees. But if the negotiation doesn't work, she's certainly prepared to represent her clients where necessary in a courtroom. When she's not in the office, you'll find her running in the river valley or on the golf course. She would love to complete her goals of running the London Marathon, October
Highly unlikely this year. Probably
there's a hesitation there, and the Tokyo Marathon in March of 2022, and I dearly hope you're able to do that. She is accompanied in her presentation today by a little dog who really loves geese. So if you hear some barking, that might be, there you have it. Okay. Mike Simons works with clients also in all areas of estate law, including grants of probate to allow for the proper administration of estate. He too understands the strains and stresses of this process and really actively fosters communication between everybody involved to resolve issues that arise before they get to conflict. But when it's unavoidable, he applies his knowledge of estate law to estate dispute and litigation matters, including family relief, there's new terminology, family maintenance and support claims. He too enjoys helping clients with their estate planning, everything from the preparation of straightforward wills and trusts, enduring powers of attorney, personal directives, as well as working with professional advisors to implement more tax-planned strategies and family trusts. So he works with both business and agribusiness clients and families address business succession issues. As an active member of the legal community, he's a past chair of the Wills, Estates and Trusts section of the Canadian Bar Association. And prior to practicing law, Mike had a career in the retail and wholesale wine and spirits industry. So we can rely on him for some other advice as well. So with all of that, I'd like to just turn it over to Allison and Mike to lead us through, and I'm just going to disappear from the screen for the time being and enjoy your presentation. Thank you.
Thanks, Kathy.
Thanks, Kathy. Mike, I love to hear that you like to do agribusiness. Farms are always my favorite.
Well, yeah, there's it's a whole other world out there when it comes to farming. As a matter of fact, we're laughing because we're both sitting in our respective homes. And I had a farm client on the phone the other day, and I said, I feel like a farmer because I'm working from home and I work from morning to night and I never get to leave the office. So just like a farmer who's always at work all day long, that's how it's the remote working seems to be that way. But and I don't have my dog in my lap because he's about 90 pounds and he'd probably break my knee. So if you hear some heavy footsteps above Allison, that'll be either my dog or my son with his size 13 feet.
Okay, well, Mike, we have promised some good stories tonight, so I hope everyone has their bowls of popcorn as they listen to some of our tales that truth can be stranger than fiction. And we thought we would start off the presentation by discussing kind of the 3 basic estate planning documents. And if you've been in other sessions this week, you will know what they are, or previous sessions for Wills Week. But we just wanted to lay a bit of a foundation before we start talking about everything that we have seen go wrong in our estate administration files. So there are the 3 documents: the will, the enduring power of attorney, and the personal directive. Usually when you meet with an estate planning lawyer, you have all 3 prepared at the same time. And then as life changes, you may update 1, 2, or 3 as they may go. And I will give it over to Mike to describe the documents.
Sure. So I always talk about enduring powers of attorney and personal directives as sort of living documents. They're the documents that take effect when someone's alive. Generally speaking, a personal directive appoints someone who's called your agent to make personal and medical decisions when you no longer are able to and no longer have capacity. An enduring power of attorney appoints someone to handle essentially your financial matters, and it takes effect either when you having capacity call it into effect, or when you lose capacity and it springs into effect. And those are documents that take effect during your lifetime. They're very important to have. In some ways, we tell clients they're as or more important to have than a will because they're going to impact you when you're alive. Probably the most important thing to know for this session about those is that when someone dies, those documents cease to have any force and effect. Flip side of the coin is the will. And a will is just a piece of paper until someone dies. So Allison, I'm sure you've had clients call you up and say, well, I'm my mother's executor. And I often say, oh, I'm so sorry. I didn't know she had passed away. And say, oh, no, she's fine. But I'm her executor and I'd like to get some information. And so a will doesn't take effect until someone dies, and it appoints someone to be the executor or personal representative or administrator of the estate, essentially. And that's the person whose job it is to deal with the will. Does that cover them off, Allison?
You've covered it off. And when a client or when a prospective client calls and asks about their mother or father's will, I always make sure to tell them that it doesn't really matter what's in the current will because they can change it at any point in time. And they may be the personal representative today, but they might not be tomorrow. And who knows whether or not they'll be a beneficiary.
No, exactly. And so as lawyers, we're always a little bit cautious when those situations come up. But those are the three documents. And then there is an intersection, one when we're dealing with an estate where the attorney who handles the financial matters has to account to the executor or administrator or PR. And that's sort of the starting point for the finances of an estate. When we have a will, Allison, we know who we're going to deal with. We're going to deal with the person appointed under that will.
Yes, the will is, well, it really depends, Mike. I recently had a will where the gentleman decided to do his own will, which is called a holograph will, wholly in his own handwriting. And in doing so, he did not appoint a personal representative of the estate.
Ooh.
Yeah, it was messy.
That does get messy, and that's a unique one. Probably less unique, unfortunately, is when someone doesn't have a will, and,
yes,
and when they die without a will, they're said to die intestate, and that can get pretty tricky, both for lawyers and family members and family friends. Do you want to, Allison, maybe talk a little bit about the difference between having a will and dying intestate?
Okay, so having a will gives you, the testator, the person writing the will, to decide who is going to administer your estate, who is going to be the person that pays all your bills, pays the big bill to CRA at the end of the day. And in your will, you get to decide who's going to receive your estate, subject to some rules, and some of those will be in our stories later on. Mm-hmm. And then you get to decide that. You also can decide specific bequests. So if there's charities you want to give to, you can do that in your will. If you do not have a will, then we have legislations or laws in place that decide who gets to apply to be the administrator of your estate. And the laws also decide who receives your estate. So who's receiving your estate is family members, but it may not be the family members you want to receive your estate. So we do recommend having the will. In the case of appointment of administrators, I recently just had an estate where the deceased died. His wife had predeceased him, and he did not have a will, and he had 4 kids. So that means all 4 kids have the right to apply to be the administrators of the estate. When there's more than one, everyone needs to be unanimous in their decisions. And to have 4 agree on anything can be very, very difficult. So it's really at the beginning having the family meeting as to who you think might be the best person for the job.
And when mom or dad dies, I'm sure all the siblings always get along and always make the same decision and
they do.
Oh yes, no. My favorite one is I had a fellow die without a will, so he died intestate, and he had an interesting life. He had 5 kids from 5 different ladies. I think only one of them was a wife, in 3 different countries. And we were left in a situation where he had a bunch of bills to pay and there was money in the bank. But the bank said, well, who's entitled to deal with this money? And normally then they said, well, bring us the will and show us who's the executor. But there was no will. And so there's no way in those circumstances to be able to deal with short-term matters because nobody is appointed as the legal representative of the person's estate.
Yes. Having a will and really stressing the importance of having a will. The will actually allows a personal representative to step into the shoes of the deceased to deal with lots of matters initially. Without a will, and unfortunately we have to tell people this, when there isn't a will, it takes a really long time for the person who ends up being appointed the administrator of the estate to have any authority to talk to anyone. And given our current pandemic and timelines with the courts, it's even longer right now. And it's frustrating because the administrator may be trying to pay bills, file tax returns, and nothing can be done until they receive a grant of administration from the court, which then says they are legally appointed to administer the estate and they have all the authority to do so. And before that, no one will talk to them or give them the time of day, and they're quite frustrated.
Yeah, and it gets very frustrating even for lawyers because let's say there's only one child of the deceased and there's no will, and it's clear that that's the person that's going to be the administrator of the estate. And we say, okay, well, we need you to tell us all of the assets of the estate. And that person goes to the bank and says, okay, bank, I need to know how much money is in my dad's accounts. And they say, well, who are you? Well, I'm his child. Okay, well, are you the executor of the estate? Well, there's no will. People and information nowadays is not easily gained unless you live in small town Alberta where
even
Sally.
then it's becoming harder.
Yeah, even then it's harder. You're right, but it's not like 20, 30 years ago where everyone at the bank was the same person that worked at that bank, and mom and dad banked there for 50 years, and you could go in and they just help you. Even if people want to help you, they just aren't able to anymore with all of the privacy restrictions that are out there.
So before we get into kind of our stories and our different things, basically, I think what Mike and I would like to stress is that most of the issues in our stories relate to failure for the testator to properly plan, or failure of the testator to really understand what they were doing. It could be maybe they didn't actually go see a wills and estates lawyer, someone who actually specializes in the area, or they've decided to write their own will. Unfortunately, after someone passes away, it costs a lot more money to fix it rather than if they would have spent the money in their lifetime and received the proper planning advice.
Yeah, and we're going to tell some stories about what I like to call post-death estate planning, which is complicated and time-consuming and expensive.
Very.
Allison, you're way nicer than I am, because you say where a testator failed to necessarily plan. I'm not that nice.
I'm warming them up. They're only on the first bowl of popcorn.
The person who died did a bad job and left a mess.
Yes.
And I say that here, I say it in jest. It's hard to say it to somebody who's grieving, obviously, and I wouldn't quite be that blunt, but
I've been that blunt, Mike. I actually had
not as nice as I thought.
She was crying on the phone to me. I'm like, unfortunately, this is your dad's fault.
Yeah. And it's kind of lousy because when you get appointed as an executor and you get left with a mess to clean up, people feel very morally obligated to deal with it. And of course, the executor's role, one of the other things we call them executor, we call them a personal representative. The other word we use often, and they're all interchangeable, is a trustee.
Right.
And part of the reason, as you said, Allison, is everything in that person's estate goes in trust to the executor, and they hold it in trust for the estate to deal with pursuant to the will.
Right.
And of course, that executor's role comes with, I often joke and say, pick someone you really, really like or really, really hate, because it's a lousy job. But that executor's role comes with a whole lot of responsibility. And it also comes with liability. And the liability or potential liability is if an executor doesn't do their job properly, if the executor does not follow the terms of the will or any court-ordered variations to the will, the executor can be personally liable for those steps that they take. If they distribute the estate in the face of claims that are existing, or in the face of a debt owing to Canada Revenue Agency, they can again be personally liable for making those mistakes.
Right.
So it certainly isn't, it's not a DIY situation very often when you're dealing with estates.
Yes, I highly recommend, upon being appointed executor, which means the person has passed away and the will is now in effect, that you do speak with a wills and estates lawyer. People can say they know what they're doing in this area, but if they practice in all areas, they're not actually a specialist. It's like dealing with a health issue. If there's a specific health issue, you're going to go see a specialist in that area. You're not going to go see your general practitioner. And that's also part of our stories for when people have gone to see a general practitioner and estates tend to go off the rails. With executor's liability, the biggest bill the executor will have to pay generally at the end of the day is a bill to Canada Revenue Agency for the taxes owing on the estate. It's deemed that the moment before the person passes away, that they have sold all of their assets at fair market value. So that means there's going to be a big tax bill potentially. And if you pay other creditors before you pay CRA, you can be personally liable as an executor. And that's pretty scary because CRA doesn't go away. My partner in the office, Chad, he's a tax lawyer, and I hear him on the phone with CRA and it just makes me cringe.
Yeah, Chad can have taxes as far as I'm concerned.
He can have taxes. They're all his.
And I guess if there's any silver lining, and I'm saying that a bit tongue in cheek, is that executors are entitled to be paid for the work that they do.
Correct.
So they're entitled to be compensated. And sometimes that's put in a will. I want my executor to receive X dollars or X percent or the like. Sometimes it's not in the will and there's a range that an executor is entitled to be compensated. I'm going to just generalize, generally between 2 and 5% of the value of the estate.
Right.
So sometimes that can be great, but one thing that people generally don't understand when they decide if they're taking compensation is that that is deemed to be employment income and is subject to regular employment deductions and the estate issuing tax notices, etc. So it's not quite as attractive as just a gift. Correct.
Any gifts that are received from an estate, the tax has already been paid, so you do not pay any tax on that. Executor's compensation. So I did have a client and her mother had dementia. She was acting as the attorney for several years, unfortunately, because mom no longer had capacity to make decisions regarding financial matters. So she had been dealing with her mom's estate from the time the power of attorney came into effect to the time the estate was almost administered for about probably 7 years. 7 years is a really long time. And as Mike and I can tell you, being an executor, it's kind of a crappy job. It requires a lot of time. I kind of tell clients like even the most basic estate is probably 150 to 200 hours of your life. Guesstimate. Mike, do you agree, disagree?
Oh,
it depends what's involved.
Yeah, it really depends. If it's husband and wife and everything goes to one or the other and most of the assets are joint, no big deal. If it's
the second passing.
Yeah, that's where it gets complicated.
So she had been doing this for a long time. The will did not specify compensation. And so then she asked her siblings, 2 sisters and a brother, if she could receive some money from the estate. And she just said, I just want 2%, so fairly low. And her brother threatened to physically harm her if she decides to take compensation. I said, well, we can make an application to pass accounts and have your compensation approved, which is a court application. And she's like, no, I'm just done. And so now here's another family that will probably never speak again. because of this issue, which is unfortunate.
Yeah, very often it's the no good deed goes unpunished. I had a good result on one where it was a tragic circumstance where two children were orphaned and raised by family members, but another family member, an aunt, had been the executor of the parents' estates, and the executor's compensation came up, and it was much higher than I thought was appropriate. And I was speaking with the guardians and going through all of this, and we were ready to sort of go to war, go to battle over this. And but I had a meeting with my clients, and the children were older then, and we were having a discussion, and that's when I found out that they actually, so there's this dispute over compensation, but they had sort of parked that over to the side. And they all still, when the aunt would come in from out of town, they'd all go out for dinner together. They'd spend time together. They were doing this for these children who'd lost their parents, because everyone knew they needed the love and support. And so they sort of parked the monetary dispute over on the side, and they kept being a family and supporting each other. And when I heard that, I thought, well, there's got to be a better solution. And I called the other lawyer up who was acting for the aunt, and I said, look, I've got a real problem with your numbers, but I got a bigger problem because if we get in a fight over this, these kids are going to lose their family again. And we have to find a solution. And the other lawyer, thankfully, was a reasonable fellow, even though he's from Calgary. And
Was he a Flames fan?
What's that?
Was he a Flames fan?
I didn't get able to see. If you go there, you're not going to make an agreement. But, and we sort of said, I said, look, I need you to talk to your client. We've got to find a solution to this, and we did. We found a fair, reasonable number. They actually came back at an incredibly reasonable solution to us, and we preserved that relationship. And honestly, it was one of my happiest circumstances in a tragic situation, that we didn't let a fight overtake what was in the best interest of the survivors out there.
That's a good story.
Yeah. So I mean, it's a war story.
I'm glad you gave a happy story.
Yeah. Sorry, I didn't mean to be all fuzzy here, but.
So, Mike, you have now been appointed. So you now met with a client, and the client has been appointed the personal representative of the estate. So how do you explain to the personal representative what your role is?
Oh, that's a good one. That's a good one. And it's an important one because generally people don't understand what the lawyer's role is and who the lawyer acts for. So when I'm meeting with somebody, I explain to them that I am their lawyer. I'm representing them in their capacity as the personal representative and executor of the estate. And so in law, we often talk about wearing different hats. So
right.
If my client is appointed the personal representative but is not a beneficiary of the estate, they're only wearing one hat. They're wearing the hat as personal representative. I represent them. And I always tell people I'm a little bit protective of my clients. I want to make sure that they handle the estate properly and they follow the terms of the will, and that they, and the other thing that we always talk about, Allison, is that they are very transparent and communicate with clients, with the beneficiaries, of the estate, because I don't know if you had the same law school professor I did, you're much younger, but I had a professor that used to look at me and go, "Silence equals suspicion, Mr. Simons."
Silence does equal suspicion.
Yeah.
And there was a lawyer, I know when I first started practicing, and he said, executors live in glass houses. So everything they do needs to be seen. And I've always kind of remembered that. And that's one of the things I tell my clients as when they've been appointed, that they need to be completely transparent as to what they are doing. Sometimes beneficiaries who are not the personal representatives of the estate get a little confused, and they try and give me instructions as to what my client should be doing or should not be doing.
Well, I'm a beneficiary, Allison. You're my lawyer.
No, I represent the personal representative of the estate and advise them in estate matters. But as the lawyer for the personal representative of the estate, we are not the ones making the decisions. We are the ones advising our clients on the different matters, but ultimately it is up to them to make the decisions. Sometimes clients, when they retain us, think that it's our job to make all the decisions and just to do all the estate administration, and that is not our job. We can assist on various matters, but at the end of the day, it is their decisions that need to be made.
Very true. That said, if I'm the executor of an estate and you're my lawyer, Allison, and I say, I don't like the way this will is written. I think what we're going to do is this.
Yeah, no. If you do that, I probably would fire you as my client, and you'd probably get sued.
Yes, there's that personal liability. But it is confusing for executors because very often what they've been told and what the will says are not necessarily the same thing. Well, they always promised me that I would get this piece.
I know.
Right?
I've been promised lots of things and it hasn't happened yet.
Yeah, me too.
Mike, you promised to send me donuts tonight and I didn't receive donuts.
Well, the Italian bakery place burned down, so I can get those ones for you, but next time.
Okay. So we've been talking a lot about the executor and their role. So really, when we think about problems in the estate, I always start with the appointment of the executor and appointing the wrong executor. So sometimes families are complicated. I know we see more blended families now. Mike, you were talking about your deceased that had 5 different children with 5 different women.
Yep.
Well, what if he actually had prepared a will and appointed all 5 of his children as executors of the estate?
Well, you know what? I know we're not answering questions, but I'm still looking. And one of them is, what type of war stories can you tell about a will that lists 3 executors?
Oh, well, that's one of my favorite estates I had. I think it's still going on, but I would have to ask another lawyer in the city if she's still dealing with it. So I did have a farm estate, and farms are my favorite because that's where things usually go very wrong. And the deceased was in a second marriage. He also had 3 children from his first marriage. He decided that he was just going to go see his small town lawyer, and he did everything, did his real estate deals, did his financing for his cows, did everything. And he got a will prepared. But he didn't really think about that his second wife didn't speak to his children. He also didn't think about the fact that his 3 children hadn't spoken to each other since they were teens. They're now in their 40s and early 50s. So he appointed all 3 kids to be the executors of the estate. But
because that's going to fix everything.
He did not put in that a majority rules clause, which means only 2 of the 3 need to agree to make the estate move forward. He just left it so that all 3 needed to be unanimous on all decisions. He then, of course, Mike, because it is a farm estate, decided to leave all of the farmland to his 2 boys to the exclusion of the wife and the daughter. Tell me what could go wrong there.
Oh, it sounds like a perfect way to spend a lot on lawyers. Yeah, that's just I often will tell people because picking the wrong executor is incredibly common, and I often, and perhaps this is unfair of me to presume, but I often say, look, if you've got 3 kids, you know which one's going to do the work anyway. So why don't you just appoint your daughter? Because very often it's they think they're being fair, or they're going to fix everything, or that appointing all three will bring them all together.
Right. But they were never together to begin with. And it's just going to drive them further apart. And suddenly, instead of having one lawyer dealing with the estate administration, everyone has a lawyer. So suddenly you have 5 lawyers, and potentially, depending on what's wrong at the end of the day, estate fees, all the assets in the estate could be used to pay legal fees, which is not the outcome any of us want, even though we are lawyers.
Yeah, it's people sometimes have a hard time believing that, but we don't actually like having to incur fees for clients or for estates. And when there's a properly prepared estate plan, typically it doesn't have to be fair. It just has to be prepared. I guess fair is in the eye of the beholder. There are certain obligations, but if in Alberta you have testamentary freedom subject to your obligations to take care of dependents, and so generally speaking, the estate costs don't have to be particularly substantial. Yeah, and appointing that joint, the 3 kids without a decision making and unanimous. I mean, what a disaster.
Gong show. It was a gong show, unfortunately. But then, as the lawyer for the personal representatives, I had to listen to all 3 and try and get unanimous instructions from all 3, which I think I have a better chance of my dog not barking at birds during this call.
Yeah, no doubt. And choosing the right executor, appointing the wrong one. I mean, part of the problem is when you appoint somebody, they don't have to act as an executor as long as they never start to, right? So they have the choice to renounce, because one question here was whether you can give an extra piece of inheritance to someone to avoid the income tax issue on executors' fees, and I've seen that done, and I've done that before. But the challenge with that is you can give someone an extra 5% of your estate, and they can not act as executor.
Correct.
So you know, there's always people looking for a quick fix or a loophole, and there's always something that works against that quick fix or loophole, it seems.
I would agree.
Yeah.
And one of the other questions is, so in addition to compensation for a personal representative, they are also allowed to be reimbursed for their reasonable out-of-pocket expenses, and that includes travel, as long as it's reasonable. So any travel time, any traveling
for the estate, not to Hawaii.
For the estate, yeah.
So they can't go to Hawaii just because they need a vacation on the estate.
Well, you know, I did have an estate where the personal representatives of the estate, it was an intestate, decided to have a meeting in Hawaii, and they asked me if they could be reimbursed for that. And I said, no, I don't think so, because you did not need to travel to Hawaii and stay in a 5-star hotel to have a meeting about your sister's estate who died in Alberta. Anyways, needless to say, the other beneficiary approved the expense. So I ended up reimbursing them.
That is
bizarre.
That is an estate I wish I was the executor of, apparently. So
I was like, you're going to pay for the Hawaii trip. Okay, nice.
Wow. Well, and part of the other problem is, I mean, I had an estate that was the most complex estate I've ever had. I always like to talk about this one. There were 56 bank accounts in 9 countries. There were multiple beneficiaries, and my client was the sweetest, the kindest 86-year-old man who lived not in Edmonton, lived in Calgary, and he did an amazing job, but it was just too much for him. It was too much for him, but his brother died, and he wanted to honor his appointment, and we still exchange Christmas cards, actually. And
that's nice.
He's such a sweet guy, but I felt badly because it took a toll on him. It took an absolute toll on him. And to the point where after 5 years, because this estate went to court about 25 or 30 times.
Did you draft the will, Mike?
No,
Just asking.
no, the will was drafted in the 70s.
Oh, okay.
And I think 2 successive lawyers had died before the testator, and it came to me, and finally my fellow just had said to me, I can't do it anymore. I just can't. And so we had to find someone who would step into a very messy estate as an independent executor. I'm sure, Allison, you like getting appointed to be executor all the time, right?
Do you know what? My parents asked me and I said no.
Well, they shouldn't have asked you, should they?
Well, and I'm like, I only have a brother and we actually kind of get along for the most part. So yeah, I was like, but they live in BC. They have an acreage. They have a donkey that live. Did you know donkeys live to be like 45?
I heard donkeys can be mean. I didn't know they lived to 45.
This donkey is mean. And my mom's like, well, you'll keep the donkey, right?
Oh, no.
I was like, no.
That's awesome.
And she's only 9. So, Mike, when my parents pass away, if they still have a donkey, would you want a donkey?
You know, I've been called similar to a donkey.
Nice in your backyard.
Yeah, sure. Let me give that some. I have a client who would take the donkey.
Okay, well, I'll give you a call. Hopefully that doesn't happen anytime soon. But
Perfect.
Yeah.
So appointing the wrong executor, we talked a little bit about that. There's a question also about how long it takes, what happens, etc. Allison, you want to talk a little bit about what lawyers like to call the executor's year?
The executor's year. The executor's year is becoming a bigger fallacy the longer we talk, unfortunately. So the executor's year is kind of the thought that when things ran more smoothly and we weren't waiting for different agencies like CRA, unfortunately our courts are backlogged, to get things done. The basic estate should be able to be mostly administered in a year. I'm now thinking the basic estate probably can be administered in 3 years, possibly. So the part of that is you have to apply if there is a will for a grant of probate. If there is no will, a grant of administration from the courts. Edmonton right now, my assistant Cindy called surrogate clerks yesterday, or no, this morning, and they're working on October applications that were submitted on October 29th.
November, December, January, February, March. So we're at 5.5 months.
5.5 months.
Wow.
So until you get that grant of probate or grant of administration, it's hard to do a lot of things with the estate. You're unable to consolidate assets. Fortunately, Justice Little has allowed us to sell property while we're waiting for the grants to be issued. But otherwise, we are kind of in a holding pattern until we get the grant because we can't get the assets from the bank accounts, deal with any investments. There's going to be a big tax bill, can't really pay CRA, taxes can be filed. I know with submitting documents to CRA to be appointed the legal representative, so that's allowing the executor to file the taxes. I think CRA is taking 8 to 10 weeks for that to happen because you actually have to physically mail it, which doesn't make a lot of sense to me.
No.
But I'm not a tax lawyer.
No. Me neither. And someone had asked what a clearance certificate is, and we've talked about it a little bit. Basically, it's Canada, I always call it Canada Revenue Agency's last bite of the apple. It's after the terminal return's been processed, and then typically an accountant will apply to Canada Revenue Agency for clearance certificate saying, this estate is done, we think we've paid all the taxes owing. CRA, take a look at it and speak now or forever hold your peace.
Right. And usually once that's applied for, that can take 6 months to a year for CRA to give that back. You can have one just to the date of death, and then you can have a second one for the period of time that the personal representative is administering the estate, because the estate does earn income. So there will need to be a tax return filed for that year as well.
Yeah, so it's I always tell clients they get quite sad when I say my average estate file. Well, this is what I used to say. My average estate file is 2 years. And you're right.
It's usually 2, but I think with the delays with everything, I know we've figured out how to function in the last year during COVID. But unfortunately, I think with our courts, they are very short-staffed, and they're now 5.5 months, which in Edmonton, which is not good. At one point, we were down to 6 weeks.
And probably most importantly, there's some questions on the Q&A, and someone had said is there you can't see the Q&A, and I think I'm not sure if only we can see it or if everyone can see it, but some of the questions do talk about timing and how long it takes, etc. That's where a big part of the transparency comes in. I've had files, and rightly or wrongly, I've had executors go on power trips. I'm the executor.
Are they the Bridezilla?
No, almost, yeah. It's like, I'm the executor. I'll decide when I tell people things.
Yes, that's not, no.
And I've had files where I've had to say to a client, look, you are not doing yourself any favors, not giving people a copy of the will, not telling them what's going on. And so, one of the questions here is, after 3.5 years and nothing has happened. Well, you know what? An estate could take 3.5 years, but if people are, I always equate it to the old, remember when we used to go to restaurants like 1.5 years ago?
I do.
You'd walk in the door, and if you're waiting for a table, you're waiting to be seated, and if a host or hostess comes by and says, we're really slammed, I'll be with you in just as soon as I can. Well, I'll stand there for 10, 15 minutes because I've been acknowledged. I've been told what's going on, and I'll wait. But if I stand there for 3 minutes and nobody even makes eye contact with me,
I leave.
Oh.
Yeah, no, that's true. It's really giving the communication. And unfortunately, as we wait for CRA, we wait for the courts, it's kind of a hurry up and wait game. They file everything. Clients can get things done and file things quickly, but then you're waiting to hear back. From the time the final tax return is filed, it can be, is it usually 6 to 8 weeks before they receive the notice of assessment, so they can pay the additional taxes. The good news is, in terms of the estate administration though, depending on the estate and the size of the estate and how it's to be distributed, usually once the notice of assessment has been completed, there can be an interim distribution of some of the estate money. So that usually makes the beneficiaries a little bit happier that they've received some money, and an accounting as to what has happened in the estate from the time of death to the time that that initial distribution was done.
Right. And I think it's very important to, I mean, people were asking about expenses being paid, or being paid for work being done on estates. I think it's always easier to justify it if you're clear about it upfront with people. I had a file where people were upset because the deceased was in a senior's home and they weren't getting any visitors. This is pre-COVID. And one of the attorneys hired their son, the deceased grandson, to go and visit, and was paying this grandson to go visit his grandmother. Well, when I first heard about it, I kind of went, ooh, like paying your grandson to go see their grandparent. That just doesn't sound like a great idea. And then I was told, well, yes, but the other sibling did it with their child as well. And if you're going on a 3 days a week to help the person,
right,
you're going to hire someone else independently, maybe it makes sense. but but if you're doing it up front, if you're clear with everyone when you're spending these monies, not necessarily getting approval, but keeping them informed, you can avoid a lot of fights.
I agree. It's being transparent up front. Another factor to these lovely estates and the length of them increasing is the condo market in Edmonton. Unfortunately, I have one estate where this condo, I think, has been for sale for a year and a half. But it's in a seniors complex and there's shared hallways, so no one wants to buy, unfortunately. So you think estates might go smoothly, but there's all sorts of wrinkles that can pop up along the way. And it's really the executor communicating those wrinkles with the beneficiary so they know what the delay may be, and going on there. So Mike, I've had battling beneficiaries, and I always find that when it's children of the deceased, they revert back to their 12-year-old selves. And they remember what their sibling did to them when they were 12 years old.
Yeah, it's sometimes the money means love, right?
And that was the principle.
Absolutely, absolutely. And so, you know, I've had files where you get good files and bad files, right? You get situations, and I had one where the elderly fellow said, "This daughter needs more help than the other two." And I've talked with my two other daughters, and they know what I'm doing. And it was 40% to daughter one, 30% each to daughters 2 and 3.
Right.
And when dad died and we were dealing with the estate, there were no hard feelings because this fellow was smart enough to talk to the daughters and explain to them why he was doing this.
Right.
Right. I've had other situations where you know, you talked about the farmer leaving the property to the sons and not the daughters, etc. And I've had other situations where there have been battle royals between beneficiaries over money, over assets, over an old piece of property that had environmental contamination that people still wanted for some reason, and we're going to court back and forth, and it's a nightmare. And it very often is the case that you'll get beneficiaries fighting over the value of things. If it's just cash, it's easy.
Cash is easy, but personal property, and I always suggest putting in a clause in the will over personal property, because I find that's where things get dicey. I know in my own life, when my grandmother passed away, my aunt was the executor because she was the oldest daughter. So she went in, she cherry picked which items she wanted, including my grandmother's wedding dress. And my mother was so angry because she thought that I should wear my grandmother's wedding dress, not realizing my grandmother is 5 feet tall and a size 2. I'm 5'8" and not a size 2. So it just wouldn't have fit. But they didn't speak for 6 months. And it's really having a way of dealing with those things. I've had a dispute over a washing machine, mom's clothes, pictures, which obviously we know we can all recreate pictures, or belt buckles.
Belt buckles, I like that.
Belt buckles, very important thing. Who was going to get which belt buckle? Harnesses for horses.
I had a good one over at gemstones, and I thought, oh, this is going to be crazy, right? There was a bag, there was a storage unit, and there was a bag full of like rubies and gems of all these sorts, and there was this huge fight, and the one beneficiary was losing their mind and said things were stolen out of it, and that the value of these things, and this was my elderly executor, and so he finally was able to wrestle the gemstones from whoever had grabbed them, metaphorically wrestle, And I said, okay, well, look, these, the way they're talking, these are going to be a huge value. And so I knew of an appraisal company in town, a jeweler that does work for
Right.
the RCMP and others. And so I had this, it was almost like a doctor's bag, you know, like one of those
Right.
old leather bags with the clasp. And I had one of my colleagues come with me, and we walked it over there because I was worried about, not that I guess my colleague could run faster than me, so I would have just given it to him to run away with. But so we walked it over to this place, and we brought it in and got a receipt for it and everything. And it took them quite a while because they get backed up and they're looking at it, and finally, and you know, I'm thinking, well, this is going to be hundreds of thousands of dollars. And the fellow who I deal with on a pretty regular basis called me up and he said, Mike, these are machine grade.
Oh, they're man-made. Nice.
No, not man-made.
Oh.
Machine grade. So they're gems, but they were used for like machining things. Like you hear of diamond tip blades for saws and etc.
Oh, okay.
So I got an education on just how crappy some gemstones can be. And I think maybe it was $2,000 worth of stones. And I think we paid about $800 for the appraisal.
Wow.
And this beneficiary refused to admit that it was so low until we said, well, you're the only one that wants them, so you can have them at this value. And then all of a sudden he was happy that the valuation came in low because it was a smaller piece of his estate that he was getting in the gemstones, which he said were worth a tremendous amount of money. So, you know, there is a lot of emotion and a lot of, as you said, sort of 12-year-old stamp your feet. That's not the way that I was promised. And, you know, there's some questions in the thing about how you resolve disputes between executors or beneficiaries, etc.
The best, what I have found in terms of resolving disputes, and I know it's pre-COVID times, was to get everyone in a room and get them a little bit uncomfortable.
Mm-hmm.
Whether or not they had legal counsel, and just kind of discuss the issues and try and hash it out. As my belief is, it's better to make a deal than go to court. I always think going to court, you're rolling the dice and yes, it's a judge, but at the end of the day, the judge is an individual and you don't know what they're going to decide. And it's better to get something rather than potentially nothing. And also it keeps the legal fees down so everyone gets more at the end of the day.
Yeah, absolutely. I always joke with people that a judge's job is to make everyone equally unhappy. So, you know, if you can maintain some level of control and find a solution, and now this is a little bit of what you young people would call humble bragging, but, and I know Allison, you'll agree with me because we talk about this quite often. I would much rather there be a good lawyer on the other side of a file where there's a dispute, because I'm a believer that a couple of good lawyers can find a solution and help clients get to a solution. I have one right now, not with you, with another lawyer in town. And my client insisted that there was no way in the world that they would ever get an offer that would be in the park of settlement. And I had a lot of faith in the lawyer on the other side, and she came back and we've got a solution to the problem between these beneficiaries.
Isn't that fantastic? I have a file that's ongoing right now, and it's a dispute file, and it's a family maintenance and support claim file. Unfortunately, the testator didn't properly provide for a dependent child who's unable to earn a livelihood due to a disability. And fortunately, the child has a wills and estates lawyer as representing them, and within 2 phone calls and 4 letters, we have settled the file. Which means everyone gets more at the end of the day. the kids will have a relationship with one another, which I think to me is the most important thing, that they will continue to get along and this will not hinder their relationship in any way.
Have you ever had a file where the lawyer that prepared the will says to you at some point, I told them this wasn't going to work?
This file I had, the lawyer for the the lawyer for the personal representative, that firm had prepared the will and they had advised the person that it was wrong. But then I've also had files where it's been contested, where there's a family maintenance and support claim, and it's the lawyer is acting for the PR who prepared the will, and he doesn't understand what the issue is.
Yeah, I mean, I had one with a farm estate where, everything was given to the children with nothing to the wife, the children from the first marriage and the children from the second marriage, and the second marriage was just a few little 30 years and two children.
It was a short one.
Yeah, and the lawyer, it was in the country, and the good lawyer, and I called him up and he said, I want to be upfront with you. I told so-and-so that this was not going to work. It was a bad will and he shouldn't do it. But he was a stubborn old, I won't name the country he was from because this is out in the country, and it was an area where, a stubborn old Scandinavian is what he said. He was a stubborn old Scandinavian, and he's not going to do a will other than this. No. And unfortunately, that estate ended up being tremendously contentious and expensive. And we ended up actually bringing in a mediator who specialized in farm estates to try and find a solution. And very often mediators are able to do that type of work, or we have the meetings like this. In this case, there was no solution to be found. We had to go to court, make applications for interim relief because this poor lady was left with nothing to run the farm with. And it was a very sad circumstance because it was completely avoidable.
Completely avoidable. And that's where we would say failure of the testator to properly plan.
Absolutely.
So Mike, one of the problems I've recently encountered, well, not recently, but I've encountered it before, is that people maybe do their wills 20 years ago and then they don't actually update them, and their assets at the time they may have done their will are significantly different than their assets at the time of death. So maybe they've done some specific bequests in the will of $1 million, but at the end of the day, there's maybe 200,000 in their estate. Have you experienced that situation?
I had one of those files exactly, unfortunately, where, I don't know, I think maybe the fellow who died didn't think he was going to live that long, but he did. And
that happens.
Yeah, I know. Sometimes you just have bad luck. And he lived a long, ripe life, and his will had a great big donation, which was very generous to charity, of, I think it was $1 million. And he died, and he had $400,000 in his account, in his investments, and he also had a wife. And so it said $1 million to charity and the residue or whatever's left to my wife. Well, for everyone who's managed to make it this far into the presentation, that specific gift or a specific request, they come off the top. So they get made before the residue. And so in that instance, it would have been $400,000. Everything that was left would go to the charity, and his widow would get nothing. Now, in that circumstance, we were fortunate that the charity was well, I mean, charity, I don't want to say which one it was, but they might be involved tonight. And
you might be on our screen right now.
I don't know about that. Kathy's on mute, thankfully. And
I told her I'd put her on the hot seat.
Yes, they had good counsel, and they said they knew that if the widow made a family maintenance and support claim, she would be successful and she would get the $400,000 because that's all there was. And so the charity said, we are going to renounce our entitlement to the specific bequest, which meant that everything went to the widow, and the estate was actually ended up being fairly straightforward, but that was a happy accident, I suppose. But that can happen when people don't update their estate plans.
And it could have been a different situation if it had been an individual rather than a charity that kind of understood the circumstances, where they thought that they should receive their bequest and then fight it out.
Yeah, and understandably, if you receive a gift in someone's will, why would you give it up?
Right. So this goes back to, and I know this is part of estate planning week, but even for estate administration week, as most of the issues we encounter or our contested estate matters go back to the will and the issues with the will, I do ask people to review their will every 3 to 5 years or after any significant change in your life. So it could be a change in your wealth, change in your marital status, whatever it may be, family member passed away, you never know. One of my favorite clients, I'm just going to talk about her. When we prepared her will, she was 102.
Wow.
She, though, and she had called me because she decided that maybe she needed a new executor because her executor was 82. She's like, I think, Allison, he might be getting too old for the job. I was like, probably a good time to change.
Wow.
But in her will, as you talk about beneficiaries, she named 72 beneficiaries in her will, and I drafted it. But she was 102, Mike. Are you going to say no to a 102-year-old?
I'm going to explain the cost of administering a 72 beneficiary estate, but
she didn't care.
Yeah.
But I did make sure that all the giftovers were to charities.
Good.
Just in case, because you never know.
Wow. Yeah, I've got an estate right now where unfortunately the will was done. It was a matronly old lady, and there are, I'm going to say 22 beneficiaries. And for whatever reason, I didn't do the will. So when Allison talks about the gift over, that means if one of those 72 people died, then their share would go to a charity. So it's pretty easy.
And I had a few of those.
Right.
But she was 102.
In my circumstance, it said to A, B, C, D, E, F, G, and if they predeceased, then to their estates. And I had and in this exact scenario, one of those people had died, and they died intestate, and they died insolvent, so they had no money, and so nobody had, and they died 5 years or 10 years before, and nobody had done anything with their estate. So they died, they had no kids, they had 3 siblings who would have been entitled to that person's estate. And I had the unfortunate job of telling those 3 siblings, if you want your dead sibling's share of your aunt's estate, you have to go get a grant of administration for your dead sibling from 10 years ago so that the money can be paid to their estate.
I recently had the same issue, and it was the deceased. And how did it go? It was the granddaughter died, and it turns out that her grandfather back in the 50s bought plots in the cemetery. And he owned, I want to say, like 40 plots in the cemetery. So we had to go back and deal with his estate in order to get the plots transferred because they were still in his name. But she thought she owned all these cemetery plots on her death. I didn't know there was a cemetery plot business, but apparently you could buy them back in the day.
Wow.
It was a very interesting matter because I was like, going back, I was like, oh, but there's nothing. It was a strange file. But
There are a whole bunch of questions just about, how do you solve disputes? What can you do if an estate's been languishing for a number of years?
yes, I see we have lots of questions. Should we answer a few before we get into loans? I like loans.
No, I do not like loans. Yeah, let's try and answer a few of them. And folks,
Okay.
I'm gonna just apologize. There are some that are very,
Kathy's coming back on.
Oh,
Kathy, are we doing a bad job?
You're doing a great job. I was just going to say, if you'd come up in the chat session as well, just to let you know.
Okay.
And one that seems to come up quite frequently is, those 72 beneficiaries, what if you can't find some of them? And then I'm going to disappear again.
Okay. Do you know what? My client, she was lovely. She had written down all the addresses for me of all 72 beneficiaries. I had the most organized file so that when she finally did pass away, that I had all the addresses and the personal representative knew who to contact. So
Wow.
she was very organized. She was a former school teacher. So she knew how to organize her files.
I had a lady like that. She was one of my favorite clients, and elderly German lady. And I was at her seniors home several times updating things. And one time she came, she said, "Come with me, come. She goes, right here. This is my death book. This is where all the information you need when I die." And I thought, wow, that's pretty forward thinking, right?
Yeah, and this is how this lady was. She had even planned her funeral. She had this nephew. And when she finally passed away, I found out that her nephew had predeceased her. And I was quite devastated by it, even though I hadn't met the nephew because she spoke so highly of him. And then the executor went to me, he's like, "Allison, you realized he was 85 years old when he died." I was like, "Oh, okay." But I just started to feel an attachment for him because she spoke so highly of her favorite nephew.
There's a lawyer joke, which isn't wills and estates, but since we're talking about 102-year-old, it's about the couple that comes in to see the lawyer, and he's 102 and she's 101, and they say, "We want a divorce." And the lawyer says, "Well, you're 102 and 101. Why do you want it? Why have you waited so long to get a divorce?" And they said, "We were waiting for the children to die."
You know what? Sometimes that's true.
Yeah. So, I mean, yeah, it's sad when an 82-year-old nephew dies, but.
So one of the things that we find is quite contentious, and it's not often dealt with in wills that are prepared by non-specialists, are the treatment of loans. So I can tell you from my own personal experience, my brother decided to start a bakery in Grand Prairie. I'm really upset it's in Grand Prairie because he can't give me donuts either. Anyways, to start his bakery, my parents loaned him $100,000.
Wow.
And he was able to get the rest. So as soon as my parents loaned him the money, I made my brother sign a promissory note, which he wasn't very impressed with because he was like, "Why are you getting involved in this? It's none of your business." But I talked about with my parents. And then my parents then updated their will to actually deal with this loan because upon death, if there's any amounts that parents may have given to children, and sometimes there's the black sheep in the child that always needs money for something. I don't think I'm the black sheep in my family, but maybe I am. Haven't asked my parents for money. The personal representative or the executor of the estate has a duty to maximize the estate, which means they need to collect all that money that has been given to that child and to what they know about it. So I do recommend putting in the will as to if there is any loan. My parents, in their case, they put that they had made a loan to their son. And that upon their death, that if he still owed the money, then that was to be taken from his share of the estate, that it would be repaid. Some people want to put in their will that the gifts will be forgiven. It really just needs to be dealt with in the will. Otherwise, suddenly there's a battle of the siblings, the executors saying, no, you owe mom or dad's estate $100,000. And the child's like, no, mom and dad told me I didn't have to pay that back.
And I've seen that time and time again where people's understanding, and I'll pick on you and your brother. Your brother thought it was a forgivable loan, and you thought it was a loan to be brought into account in the estate eventually. And you know, mom and dad can do whatever they want with their money, but
Right.
if they don't deal with it at the time they make a loan or in the will, it becomes a reason for siblings to not get along in the future.
Right. And I know housing is a lot more expensive. I'm seeing clients where they're gifting children the down payment on their first home or condo. And then it's what happens to that money at the end of the day. Is that to be forgiven? Some want to make sure the children are all treated equally. Some say, no, this child needs the money more. It really depends. And there's no right or wrong answer. It just needs to be put in the will as to what's to happen to it so that the executor knows, and they may not be chasing after one of their siblings, if the case may be, to collect the money.
Yeah. And you know, a string of questions, and folks, I'll just say, like, the general questions are very helpful. The very specific ones we won't be able to get into tonight. It's just not appropriate or sort of the forum for it with our storytelling. But a lot of the questions are, what do you do if you can't get along? Can you go to court, etc.? I will say that estate law is a unique area in that respect, in that there is something, I'm letting a little secret out of the bag here, called applying, and I guess I should say it was a lot easier pre-COVID. It's called applying for advice and direction. And so in an estate, you can go to court and you can say to the court, here's what's going on. Typically, if you are advocating on behalf of a beneficiary, it's different how you would frame it. If you're acting for the executor, it's different how you frame it. If I'm acting for an executor, I'm saying, we have a problem. The beneficiaries won't agree on X, Y, Z. Court, can you please tell us how we should proceed? And that's the advice and direction. If you're a beneficiary and you're unhappy because an executor has taken 5 years and given no communication, then you can make such an application to the court to say, it's been 5 years, I've gotten no information. Court, can you please make the executor do something or replace the executor? So there are those mechanisms, but I am tremendously oversimplifying it. Allison, I'm sure you can just get to court for about $500 and a quick.
No, I wish. I'm doing 2 applications right now. There's a lot of information you need to put in. But the applications for advice and direction are kind of the last resort. It's trying to come to some sort of agreement before that, if it can be agreed to. But if the executor really needs direction, then they need to apply to the court. In the case where the executor has not done anything in 3.5 years, then that might be an application that the beneficiary of the estate makes to the court to either have the executor removed or have them to pass their interim account, or just to find out what's really going on. The executor does have a duty of honesty and good faith. They need to have open communication with the beneficiaries of the estate and let them know what is happening.
Yeah. No, exactly. There are also some questions about tax questions. And as Allison has said, her colleague Chad is a very good tax lawyer. Matter of fact, I refer clients to him. Sometimes you need a tax lawyer. Sometimes you need an estate accountant, someone who practices in that area. You're not going to get answers to tax questions from me or probably Allison. So some of the questions here, there's a question about what if the gems were real and very valuable, what would the tax implications be? It's a really good question for an accountant or a tax lawyer. But as lawyers, as estate lawyers, generally, we're not going to give tax advice. We're not going to, the advice we'll give is get tax advice.
There's someone who's asked, can a lawyer with the permission of the executor and the beneficiaries ignore a will made by the deceased? The answer is no. We have a legal duty. So no, we can't ignore the directions of the will. What I do tell clients if they want to ignore whatever is in the will, one, they don't have to retain me, or two, you know what, follow the terms of the will and then do something on the side afterwards.
Yeah, although I will say that this is part of my specialty of post-death estate planning. I say tongue in cheek. I've got a file right now where the will was very heavily weighted to one child over another. The two siblings decided on a reallocation of it, but neither of them were the executor.
Okay.
And so what we ended up doing is a consent order between the beneficiaries and the estate. So there is a reallocation under the estate so that the executor is protected and can distribute the estate based on what they have agreed upon. So you can't ignore the will. You can agree to change how the distribution is going to be. As Allison said, informally, it's a lot easier to just say, get your money and then equalize it. But there has to be, I guess, a certain amount of faith and trust in doing that.
You don't trust people, Mike?
Plan for the worst, hope for the best.
That is what I tell clients, plan for the worst. And I guess, in your case where it was a reallocation, yes, that can be done by consent order or whatever the clients agree to. But if it's something you're completely ignoring, maybe one beneficiary or something, who knows?
Yeah.
It really depends on the specific will. So, Mike, I had a client and they told me that they had this great investment that they want to invest the estate in. And the investment had a 15% return with dividends paid quarterly.
That sounds too good to be true, Allison.
I know. And it's kind of good timing because I saw Bernie Madoff died the other day.
Oh, couldn't happen to a nicer guy. Deal with that estate, eh?
Yes, I bet that estate's going to be interesting.
Yeah.
So what do you tell clients when they come to you with these opportunities?
Well, it's very interesting because you talked about having to get a clearance certificate for an estate. On a simple, straightforward estate, I'll very often tell clients, you don't want to earn money in the estate.
Correct.
Because if you earn money in the estate, you're triggering another tax return, another clearance certificate, etc. So once in a while, I'll have an estate. Let's just, for example, say I have an estate, and in this estate, I have $300,000 in my lawyer's trust account, and the executor will say, "Oh, we should put that in a daily interest account or a GIC." And I say, no, we shouldn't, because
no, we don't want to earn any income.
Yeah, you're going to earn $30 of interest, and you're going to pay the accountant how much more to file another tax return. You're going to extend the estate another year by doing that, etc. So generally, I encourage people not to earn money in an estate on purpose. There are times when an estate does earn money, and there are rules usually set out in the will that talks, a properly drawn will that talks about what type of investments an executor may make on behalf of the estate.
Right. And generally those are not the high risk investments. So any investment that may be a Ponzi scheme, you should not be investing in.
Whether you're in an estate or not,
Correct. I did have an estate where the executor thought it was good to invest in high risk uranium stocks.
Wow.
Like penny stocks. Lost $1 million.
Well, and it's if it seems too good to be true, right? It's those circumstances. It's challenging because executors, if you've not done the job before, you're lucky. And when you get the job, there, hopefully you have a good lawyer guiding you. One of the questions was, does the lawyer do everything, etc.? No, lawyer doesn't do everything. I don't go and clean out people's houses. I cleaned out my parents' house, but well, actually my sister and my wife did that. But lawyers are there to make sure that the executor understands what their duties and obligations are, to make sure that they follow the terms of the will. And sometimes they have to help clients realize that there are things outside the will that they have to deal with as well. You ever had, Allison, where mom and dad were told by the bank, oh, just put your daughter on your account and then she can pay your bills, and then it's just taken care of. It's easy.
Right. The problem is, what if the daughter or son has a gambling problem?
Yeah. Or what if that account happens to have $500,000 in it and mom and dad die, and that account that they're on is a jointly held account with the right of survivorship, and now daughter has a $500,000 account.
Right. Yeah, so that creates some confusion because I don't think the banks have read the Pecor and Madsen decisions, Mike.
No.
So those are decisions from the Supreme Court of Canada, and they were from 2007, 2008. And basically what they said is, when a parent gives money to a child, or puts a child on a bank account, that it's deemed that they're just holding it in trust for the estate. If it's money given to a child, so pre-giving gifts, I know some parents like to do that. They like to give money ahead of time before they pass away. They need to actually show that it was a gift. Otherwise, it will be deemed to be a loan, and then the executor will be required to collect it. So the presumption is it's always a loan unless proven otherwise.
Which is good, because it's generally done for convenience, not for inheritance or survivorship.
Yes. I recently had a client tell me that the bank didn't want an enduring power of attorney for one of my clients. They would just prefer to put the child on as a jointly on the account.
Well, for banks, it's easier, right? I mean, it's much easier for them to just have the person as an account holder. They don't have to worry about whether the enduring power of attorney has been done properly, if it has to be triggered, etc. I mean, I get it.
I get it, but it creates a whole bunch of legal issues after the fact. And as what was your law professor saying, Mike?
Silence equals suspicion.
So silence equals suspicion. So maybe a child is helping mom or dad pay bills or do whatever. The bank's like, oh, we'll just add you on because it's easier. And suddenly mom or dad passes away, and suddenly there's all these questions. And that's one of the questions I do ask the personal representative if they are on a joint account is, what is your understanding of this account? Fortunately, my last one told me it forms part of dad's estate. I was like, good answer.
I'll give you one last one since we're talking about that, and Kathy's about to pop back up. I have one right now where joint account, totally done for convenience. And mom died, son was about to deal with mom's estate, son died.
Ah.
The only thing in son's estate, everything was held jointly with wife, is the only thing in his name solely is mom's bank accounts, which are now his. And now wife has to get probate on husband's estate so that that money can be paid over to mom's estate. So best laid plans, unfortunately, are causing a lot of grief and a lot of consternation and concern about how to deal with it.
My favorite is when they put the house into joint names to avoid probate.
Oh, yeah. No. No.
Sorry, Kathy.
No, this could, I enjoy your stories forever, but we have promised that 8 o'clock is our ending time tonight. So, and so thanks to all, well, first of all, thank you, Allison and Mike, for your stories and your wisdom. This has been fabulous. Thank you to all the attendees for joining us for this evening of stories. It's a different session than the others that happened during the week, and always very popular for Wills Week too. So thank you so much. You bring tons of experience, some of it great. I mean, you're very experienced, but some of your experiences have been great, and some of them have been problematic to be cautionary tales for others. And I just very much appreciate, and ECF, Edmonton Community Foundation, really appreciates your wisdom and experience tonight.